Welcome to Sources of American Law by
Stacy, Dostie,
and Denise, Bolger. There are four primary sources of law in America.
1. Statutory law includes all laws passed by Congress, state legislatures, and local governing bodies. 2. Administrative law is made up of the regulations created by administrative agencies in order to carry out their duties and responsibilities.
3. Case law refers to the decisions reached in court cases. And 4. Constitutional law is comprised of the laws of the U.S. Constitution and the various constitutions of each state.
Here's a snapshot of each source of law and how they affect us today. To create a statute or law, a bill idea is first submitted to the legislature by a member of the House of Representatives, the Senate, or a joint standing committee. The governor or the president can also submit a bill idea. Bill ideas come from the people that legislators represent. In Maine, the staff of the Revisor's Office, the Office of Policy and Legal Analysis, and the Office of Fiscal and Program Review write the bill text. After the bill text is written, the bill is given a number, assigned to a joint standing committee, and then placed on the legislative calendar. Maine has 17 joint standing committees. These committees oversee Maine's departments and agencies. Each committee has 13 legislators on it. Each bill has a sponsor and co-sponsors. The sponsor is the legislator who submitted the bill idea. Co-sponsors are other legislators who are interested in supporting the bill. Another type of legislation is called a resolve. Resolves may instruct a department, agency, or stakeholders to report back to a committee on a certain subject. After a bill is sponsored, it is sent to a joint standing committee for a public hearing and then a work session. At the public hearing, the committee hears from people in support, in opposition, and neither for nor against the bill. At the work session, the committee works with stakeholders to revise the bill so it works for all of the parties involved. A committee is allowed to have more than one work session on a bill. When work on a bill is completed, the committee votes ought to pass or ought not to pass on the bill. Bills that are voted ought to pass continue in the legislative process. After a committee passes a bill, it is sent to either the House of Representatives or the Senate. If a bill's sponsor is a House member, the bill starts the voting process in the House. If a bill's sponsor is a senator, the bill starts in the Senate. For a bill to pass and become law, it must make it through 2 readings and then enactment in both the House and the Senate. Administrative law covers the rules of each government agency. Maine has 20 departments and 31 independent agencies. The head of each department or agency often has to report to their joint standing committee to update the committee on bills or resolves that are due to be reported on. For example, the Utilities and Energy Committee oversees the Public Utilities Commission. One of Maine's departments is the Secretary of State's office. Matt Dunlap is the Secretary of State. What functions does the Secretary of State's office provide for Maine?
Well, a little bit of everything. It seems like there's nothing that we don't touch. The original function of the Office of the Secretary of State was to keep the records of the acts of the legislature and the governor, and that's translated now into the state archives. We have just about 100 million permanent records going back to 1639, about another 200 million non-permanent records. Records that are kept for a statutory period of time, like anywhere from 3 to 50 years, depending on the record. That's the physically largest part of what we do. The next largest part is corporations, elections, and commissions, because we're the record keepers. We keep records of filings of corporations. We do about 79,000 corporate entities every year. Wow. We are responsible for the tabulation of the vote in the election, and we supervise the printing of ballots for every election from every county seat, whether judge of probate, county commissioner, sheriff, register of deeds, etc., up to the President of the United States. So we do all the federal elections for the U.S. Senate, Congress, President. We do the legislative elections, obviously, for House and Senate. Yeah. And in a primary election, we could be looking at about several thousand ballot styles among the 503 organized towns that conduct elections. And then the biggest part of what we do is the Bureau of Motor Vehicles, where we register about 1.5 million vehicles, a lot of trailers in that, those big trailer fleets make up a big part of that. Okay. Also, we license just over 1 million drivers in the state of Maine. Wow. And we suspend about 85,000 licenses a year for various causes, from point accumulation, failure to pay child support, operating under the influence, that type of thing. So
Okay, great.
that's basically what we do. We do a lot of other things too.
Can you tell me about the rulemaking process for departments and agencies?
The rulemaking process is really a poorly understood form of governance, because it used to be, back 100 and some odd years ago, that everything was done in statute. So if you adopted a child and wanted that child to have your name, it took a private and special law enacted by the legislature to change that name. The probate code changed that. Then further along, like for instance, every couple of years, the Department of Inland Fisheries and Wildlife revises its fishing regulations. We got 5,000 bodies of water and 3,000 miles of lakes and of rivers and streams. So, to do that in statute would be an enormous undertaking. So the legislature authorizes the department to, gives them an umbrella to do this in rules. So there's two types of rules. There's routine technical rules, which are fishing regulations, and then the things that are very complicated that the legislature wants to have a final say on, and that's the major substantive piece. So, the legislature will charge a department to do something in major substantive rule. They work out all the technical details and then bring it back to the legislature for final approval. Routine technical rules are done on a routine basis. There's typically a regulatory agenda that's published every year by an agency. Some agencies do a lot of rulemaking, like agriculture, marine resources has an enormous responsibility for rules for shellfish harvesting and that sort of thing. There are a lot of different public interfaces. What we do in the Secretary of State's office is that we compile all those rules into one place and we publish them, so that a citizen looking to find out what the rule is on clam harvest in Phippsburg can go through our website and find those rules. So the rulemaking process happens under the authority of the legislature, but it's conducted by the regulatory agencies. So they're not really, the rules have the force of law, but it's brought some attention to this whole process lately is when agencies promulgate rules that are in conflict with enacted legislation. And so I'm an administrator. I administer the law as directed by the legislature, signed by the governor. If I have to promulgate rules, those rules really exist within the scope of that framework of the law. I can't countervene the law. So that's really a major difference. But rules are very, very important. No question about it.
The cases in court are often a matter of which one do you believe, the prosecutor or the defendant? Or in a civil dispute, the plaintiff or the defendant. Other times, it's a matter of how to interpret an existing law in a specific situation. That's when case law is established. The outcomes of many cases have had a major impact on American life. Some examples of familiar and important cases are Roe v. Wade, 1973. The U.S. Supreme Court ruled that state anti-abortion laws were unconstitutional except in the last trimester of pregnancy. Brown v. Board of Education, Topeka, Kansas, 1954. The Supreme Court found that laws forcing equal but separate schools violated the Equal Protection Clause of the 14th Amendment. Miranda v. Arizona, 1966. This case established what we know today as Miranda rights. Before questioning, police must notify the suspects of their rights. Most of us are familiar with these rights through TV cop shows and movies. You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you desire an attorney and cannot afford one, an attorney will be obtained for you before police questioning. The Attorney General's Office prosecutes many cases for the state of Maine. Janet Mills is our Attorney General. Case or two in the state of Maine that might have changed some state law.
Plenty of them.
Yeah, you have the background. For sure.
Almost every case that goes to the Maine Supreme Court changes something about Maine law by interpreting a constitutional provision or interpreting a Maine statute where there's any ambiguity. Because there are criminal cases and there are civil cases. Right now, this office is litigating cases about, for instance, the clean elections law, and that's in federal court right now. A good piece of it is in federal court, where some parties are trying to say or saying that the Maine Clean Elections Law was enacted by the people by referendum more than 10 years ago, violates rich people's First Amendment rights, for instance. So we suggest that no, there's an overwhelming public interest in maintaining the integrity of our election laws and allowing people to run for office without having to raise a bunch of money from private sources and special interests. So there's that balancing act. And so about 10 years ago, the First Circuit Court of Appeals, the Federal Appellate Court, ruled in our favor on this exact same issue. And so when the new suit occurred, the Federal District Court ruled in our favor by denying a TRO being a temporary restraining order that would have enjoined the law. Now the Federal Court of Appeals has scheduled that case, the appeal of it, on an emergency basis for next Tuesday, October 5th. So, which means they're taking it very seriously, and of course we're taking it seriously too. But in light of some of the U.S. Supreme Court rulings and emergency orders they've issued in, for instance, Arizona, we're going to be arguing strenuously that our law should stay on the books, should not be enjoined, and should be upheld at least throughout this election period, election cycle. It would be very unfair to the 81% of candidates right now running for office relying on the Clean Elections Law. Extremely unfair to them to pull the rug out from under them at the very last minute. So there's an example of a case that's wending its way up on in the appellate level that will set some standards for Maine law in that area in Title 21A. We try to fashion the law as it pertains to the state in a creative way, in a way that benefits the most people and reserves scarce state funds for vital services. We do that every day in all kinds of ways. We don't just litigate cases in courts. we also litigate before administrative bodies, and we represent licensing boards. We represent state agencies and department heads in legal matters every day. So when you ask about case law is a very small part, going back to your question, very small part of what my office does as a whole.
The United States Constitution was signed on September 17, 1787, at a convention of the delegates of the 12 states. It established the three branches of government that still exist today. The legislative branch, which is comprised of the Senate and the House of Representatives, the executive branch, the President and the Vice President, and the judicial branch, which is the court system. The first 10 amendments to the Constitution are known as the Bill of Rights, and they were ratified on December 15, 1791. Today there are a total of 27 constitutional amendments. They include many freedoms and protections for the people, such as freedom of speech and religion, the right to bear arms, no unreasonable searches and seizures, the right to a speedy trial, no cruel and unusual punishment, and the right to vote regardless of race or gender. In addition, each state has their own constitution establishing state government and state lawmaking. Maine's constitution was established in 1820 when it became the 23rd state of the Union. The reason the U.S. Constitution was adopted is immortalized in its preamble. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. To ourselves and our posterity do ordain and establish this Constitution for the United States of America.